of the particular suit, my lord, the particular suit is out of the jurisdiction and the plaintiff is required to be returned following the
that point should be considered by the trial
I have
court. Why
already
you have come here?
no further extension to be made, my lord, without considering my Order 7, Rule 11 and the, my lord, order, these applications, my lord.
So you have challenged the order, impugned order.
My lord,
Where the interim injunction was granted.
Yes, if the suit is itself, the plaintiff is, my lord, if my lord kindly have a look to
Why
the...
you have not filed the vacating application?
Yes, your lordship.
Why you have not filed the vacating application?
My lord, I have filed that.
Injunction.
Yes,
If
I have
you
filed that, my lord. I have annexed
that
that.
application has been filed.
Yes.
Where is that?
My lord, that is annexed P2 is the Order 7.
Case number?
Page number 23. The Order 7 Rule 11 application. And, my lord, Order 39 Rule 4. That
Where,
is
order 9, 34, order 39, rule 4. Where is that?
Order 39 Rule 4 is this, my lord. That is at page 28.
Let both the application be decided by the trial court.
Expeditiously as possible, my lord. And, my lord, considering the Court Fees Act, West Bengal Court Fees Act, provision of the court.
That is considered
my
by the
lord,
trial court, order 7, rule 11.
Yes. My lord, kindly consider, my lord, kindly.
By filing this application under Article 227 of
Your Lordship, I am appearing for the petitioner in this matter. I am praying for not today, Your Lordship.
Oh, first of all, this is an appealable order. With the appeal should have been filed before the learned district judge. And my lord, there is a notification. The learned district judge is sitting tomorrow, my lord.
Your Lordship, I am led.
Playing for not today. He's
Yes,
he's
Your Lordship,
playing
I
for
am
not,
Mr.
Stay of vacation, my lord, it becomes very difficult. There is no urgency.
not vacancy.
Lordship.
A vacation court I will fix after.
Before the
No, Your
resurrection, my
Lordship.
lord. Let's
No, Your Lordship,
No,
kindly
no.
give us not today or else pass it over. I shall come back, Your Lordship.
They have not even complied with the order.
What was the order?
My lord, I have been expelled from a club. That expulsion order has been stayed by a well-reasoned order. Your lordship kindly takes the impugned order. Page 237.
What do you want now?
Your Lordship, I am just praying for not today because the
There is
senior
no
counsel.
urgency. Let the matter be fixed
Then kindly
after
keep it-
vacation.
30th of
What is the
October.
Kindly
urgency?
keep it at 2 p.m. Your Lordship shall come back.
Then where is the urgency?
No urgency.
They took leave and
Your Lordship, there is urgency in this matter. Your Lordship, kindly.
What
give
is
us-
the urgency? Stay
Kindly
order
give
was
me
granted
opportunity,
by the
Your
trial
Lordship.
court.
I have had to
I
file
shall come back at
complaints.
2 p.m. Your
I have
Lordship.
had to file complaints against them. There's an order under 107.
2 p.m.
142.
My lord will kindly keep it. My lord, there is no urgency whatsoever. My lord will
My-
kindly
kindly
take character
consider.
duty. They
He
say,
is
My Lord,
seeking.
kindly consider my senior is not here at
Senior
this
is not
moment.
there. Let her senior comes
let it be, let it appear before
on
the
16th.
judgment.
Yes, Your Lordship.
16th?
16th, Your Lordship.
Yeah,
Kindly, Your Lordship,
16th
keep
I
it
have
for 16th.
You have difficulty.
Yes.
So you have to wait up to 2.
Then 2 p.m. Your Lordship.
Pass over.
Oblige, Your Lordship.
I appear for the petition. My lord, both the court below, my lord, refuse the order of injunction. First of all, my lord, I am defending petitioner. My father was my lord, took the loan of rupees 55.
Wait. Which order you have challenged?
Challenge, my lord, the appellate court order.
What is the matter about?
Matter, my lord, relating to the, my lord, my father, my lord, took the loan of rupees 55,000 from the plaintiff. My lord, at the time of the insecurity of the landed property. My lord, this landed property, my lord, obtained the specific performance of contract degree against me after the death of my father when I was the minor. I am the minor who is the party to the proceeding. That is the order 32 of the Civil Procedure Code. And thereafter, my lord, after obtaining the execution proceeding has been filed in the year of 2011. 2013, I came to knowledge that execution proceeding pending, but I am take the possession of the suit property. Now I am in possession of the suit property. I filed a separate suit in the year of 2013.
Why you have filed the separate suit when there was a degree?
No, separate suit regarding by the declaration and injunction of the suit property that I have no knowledge about the degree, about the what the specific purpose of the contract has been passed. Thereafter, my lord, filed the first appellate trial court, my lord, refused the order of injunction. The appeal court goes. Appeal court, my lord, same order is affirming. My lord, I prayed for my lord,
Rightly rejected your application.
my lord, this is not rightly, my lord. I have to, my lord, decide the adjudication issue whether, my lord, I have the minor or not. My lord, that has to be adjudicated. And degree was an ex parte. I filed an ex
No,
parte.
you are minor at that point of time. Whenever you became a major,
By the court of appointment, that is order 32 rule 3, by the appointment of the court guardian, but that has not been gone into. Thereafter, my lord, I filed the order 9 rule 13. But by the before the court below, my the learned lawyer that did not take steps, that has been dismissed for default. My lord, so that they have been
solve
filed a
the
separate.
copy then.
Yes.
You solve the copy. I am not passing any interim order. The instant application.
And the appellate court has rejected the stay application of the petitioner without ascertaining any reason. Actually, what happens, they over the same suit property, case and counter case, suit for declaration and injunction. We have filed a suit for declaration and injunction before the learned civil judge junior division first court. First we have filed. Thereafter, learned junior division was
Declaration and injunction.
in respect of the property, and this
You are the owner of the property.
yes, I'm the owner of the. I am in possession of the property. I have got lot of documents to that effect because my father is the owner of the property after the said demise.
You
of
have
the father.
filed title suit 592 of 2025.
No, that is their case. I have filed the first case, that is TS 584 of 25. I'm coming to that, my lord. Now we have filed the first case with a prayer for declaration along with injunction. And learned junior division court was very much pleased to pass an application under order 39 rule 1 and 2 restraining the opposite party. That is here the opposite party. Now that order was passed on 25/4/2025. Now after a lapse of 4 days, the other side also filed the same application with the same property, and in that case the learned same court has passed the same order. Now after a lapse of 4 days, I'm coming to both the order I have annexed. Now I have just challenged the second order, which was passed by the civil judge before the learned district judge in the form of misappeal, along with the stay application. And district judge was very much pleased to send the matter to the additional judge to consider the application, stay application. And we appeared there, and the stay application was heard out after a lapse of 4 months after filing the stay application, whatever may be, because court was lying vacant on that occasion. And that stay application has been turned down by the learned appellate court without ascertaining any reason. Kindly come to the first 2 order, which was passed by the civil judge in my case and counter case their case. Page 53 is my case. Kindly come to page 53. It is my case. Start from page 53 and the order dated 25/4/2025. Kindly come.
53, yes.
Page 53.
Where is your application, title suit application?
Yes. Next application is page 54. My
You
application.
have filed 584 of 2024.
Now the order is prior to that 53.
Please come to the schedule.
Now the second application
Please
kindly
come
come.
to the schedule.
Yes, my lord, 64. Schedule, yes.
19 decimal total land.
Total land 19 decimal, and we are in position since long. We have record of
Where
rights.
where is the application filed by them?
My lord, yes,
Title suit
yes, their application is kindly come to 64.
64.
64.
No, you have
64 is
not
there.
annexed the title suit filed by them.
Yes, they have
Where is
filed.
that?
They have filed the titles.
Where is the title suit application filed by the
Other
defendant?
side.
Yes.
My lord, the order is here. Order is there.
Order
But
may be there, but
Yes.
where is the schedule?
my lord, the schedule is clear from the order of the appellate court. Kindly come to the order of the appellate court. Kindly come to the order of the appellate court. Last part of
Yes,
my
please.
application.
Which page?
Last part of the application.
Originals.
Yes, in my application, last part.
Yes.
Order dated 2/9/2025. Should I read it will be very crystal clear from the order.
Yes.
Just first paragraph, learned advocate for the appellant moves the stay application and submit that this appeal has been filed by the appellant against the order of injunction dated 28/4/2025 passed by the learned civil judge junior division first court in connection with TS 592 of 25. That is their case. We have challenged that case, whereby the learned court has directed the appellant and the respondent to maintain a complete form of status quo over the suit property, although the appellant are in possession of the suit property since long. Moreover, the appellant had filed a TS suit. This is my case. 584. This is number, kindly consider. 584, my case. And their number is 592. So against the respondent of this case before the same court, and had obtained the order of the interim injunction against the respondent on 25/4/2025. That is, our order is 25/4/2025. And their order is 28. Now, And he further submitted that the respondent have subsequently filed the TS number 592 of 25 against the appellant and has suppressed the fact of the title suit number 584 of 25 before the learned trial court filed by the appellant against them, and have obtained the order of the interim injunction against the appellant, which is bad in law, and the said order cannot be sustained. Hence, he prays for a stay the order of the ad interim injunction passed in TS 592 of 25 against the appellant till the disposal of the misappeal. Peruse the record. It appears that the learned trial court has passed an order of the ad interim injunction of 28 for 2025 in TS 592 of 25, directing both the parties maintain to complete form of the status quo over the suit property as mentioned in this schedule till 3/36/2025. The appellant has not filed any certified copy of the plain TS 592 as well as.
Both the order are, both are order are same.
Now, my lord, kindly come to the last part of the order. Kindly come to the why the application was rejected.
No, both order are status quo.
Yes. Now the problem is this. Because we are in position, we have got the documents to that effect. I'm just
That may be your position, but status
everything.
quo is there.
everything. I'm just annexed here with all the documents here.
Okay.
But unfortunately, that petition was turned down. So kindly stay the impugned order and kindly direct me to serve the
Go
copy.
before the trial court.
My lords, can I suggest one thing?
Hmm.
Can I suggest one thing? In the meantime, the impugned order, because we cannot work anything else as because the interim
No,
order
no,
is
in
against
your
us.
case, status quo order was passed, subsequently status quo was passed.
My lord,
Same order passed and both should be maintain status quo.
My
What
lord,
is
the
the
fact-
problem?
No, my lord, the fact remains here.
That both
that-
both the titles
We
should
are-
be heard.
My lord, we are prejudiced with the order passed by the learned civil judge because we are in position since long. Kindly sees we have got the
No, the
documents.
status quo
Yes.
will not disturb your
But the
position.
problem is police is because we are not going to do anything else in my property. Police is disturbing in respect to the order passed by the civil court. Police is saying that one, yes, a status quo order is there. You will not do anything else.
Learned
So this
counsel,
is the problem.
this instant application file under order under Article 2
Yes. My lord, only direction for speedy disposal, what happened? Because I am the petitioner husband, I filed a suit for divorce.
এটা ক্যান্সেল বন্ধ করো, ম্যাট্রিমোনিয়াল সুদ বন্ধ।
Lordship, in this matter, the petitioner is praying for expeditious disposal of one title suit 289 of 2020, Your Lordship.
When you have filed this application, the title suit.
Lordship, in the year 2020, 289.
What is the stage of the proceeding?
Lordship, presently a petition under Order 1 Rule 10, the hearing is pending, Your Lordship, before the concerned judge, Your Lordship. The next date being 11th of November 2025. For the past 5 years, Your Lordship, no substantial proceeding has taken place, Your Lordship.
Have you annexed the order sheets?
Lordship, the last order is at page 25. The order is running from page 14 onwards. It's a suit for declaration and injunction.
There are so many petitions pending before the trial court.
Lordship, the
What
petition
are
is
those?
Order 1 Rule 10, Your Lordship.
No, petition dated 15/7/2025.
Lordship, multiple defendants had died
12
because of
March 2025, 24 and 26/11/2024.
Lordship, those are all petitions under Order 1 Rule 10, Your Lordship. The defendants had died. Subsequently, we had filed petitions for substitution of the legal heirs, Your Lordship. But the problem, Your Lordship, is that constantly the legal heirs and the defendants are praying for adjournments, Your Lordship. Because of which the hearing is not proceeding. On the next date, it has been fixed for hearing.
Objection has been filed.
Lordship, objection has not yet been filed, Your Lordship, by the defendants.
So all application filed by you?
Lordship.
All the 3 applications?
Lordship. Lordship, may kindly come to page 25, the next date being 11th of November, and it's written as WO, if any, in the meantime, to be filed before the date of hearing. Nothing has been filed till date. They are deliberately keeping the suit pending.
Okay. Present petitioner
I am for the petitioner. I am plaintiff for,
Yes,
yes, I am for plaintiff petitioner hearing, suit for partition and permanent injunction. Peculiarly, the plaintiff's predecessor, my father, they died on 10 February 1995, but deed was executed on 14/6/1905. By this,
after the death of
after
your
the death
father,
of the,
who
on
has
that,
executed the deed?
sorry, it was commission. It was commission. It was by commission. But I paid for an application, application for expert opinion of the signature. That application has been rejected.
Where is your death certificate?
This certificate is page 45, my lord, G annexure G, and deed is page number 30,
45.
45 G annexure G, my lord.
Sheikh Gulam
Sheikh Gulam,
Mustafa, your
Mustafa.
father,
yes, my lord.
is your father.
Yes, my lord.
He died on 1995.
10th February 95. Deed is page number 30, annexure C. 30, page 30, annexure C.
Eligible copy. You have typed.
Yes, yes, every page I have typed.
Which page?
30, 30A. Page number, kindly.
Is
see the
there
page.
deed?
This is sale deed
Sheikh Saifuddin
in favor of defendant. Predecessor of interest of the defendant. Only last page on the deed, page 38. Sheikh Gulam Mustafa.
when the deed was executed?
14/6/1995. Commission was held on 11/11/95.
Where is the impugned order?
Imperial is the last page, my lord. 7/4/25.
Do you have the original death certificate? You do not have. But your wife was there.
Yes, but they are not put any signature. Kindly, Commissioner, read the Commissioner endorsement, page number 30. It has been typed on 31 by A. Fatima will be denied to put any signature or
Been executed prior to your death.
yes, ma'am.
Prior to his death. Execution was made
Execution
prior.
after. Death was February. Execution date is June 6, 14 June 95. Page 31 is the commission endorsed his written that. So he visited the residence of the Fatima Bibi, but she did not put any signature or LTI. It is typed copy on 31A. I humble prefer stay the for limited. One, 2, 3, and 5 to 8 is file his written statement. It is statement in page number 24.
The present petitioner is the son of late
Definitely, I am for the petition. So the matters relates to guardians and wards act, the petitioner being the father of a child of 11 years, male child, filed an application under the Guardians and Wards Act
এটা বন্ধ করুন
I am thinking about Kali Puja, but my lord, by 16th, my lord, notice cannot be served, my lord. It is that.
Stay for weeks.
Well,
I beg to appear on behalf of the petitioner, my lord. My lord, the order impugned, my lord, is at page 294, my lord. There's an order passed by the Debt Recovery Tribunal, Kolkata, my lord, refusing to grant a stay to my application seeking for quashing of an order passed by the district magistrate under section 14. Now, my lord, if your lordship kindly comes to the order impugned, my lord, kindly comes to page 295 once, my lord. My lord, my predominant point of challenge was the classification of the account as
no,
NPA.
you have filed an appeal.
No, my lord, I tell you, lordship, my lord.
Before the tribunal, you have filed the appeal.
My lord, that is, my lord, the appellate court, due to the puja vacation, my lord, kindly comes to the very next page. I have annexed the resolution. I have not filed, my lord.
Yes.
My lord, the appeal court is not in session. I cannot avail that remedy before the appeal court now. My lord, that is why I'm before your lordships, my lord. I tell your lordship, my lord. Section 14 order challenged before the DRT. DRT passed an order refusing to grant any protection to me. Now, my lord, my next course of remedy is appeal. The appeal court is not in session because of the vacations, my lord. I have annexed the resolution at page 296. Now, my lord, I am left remediless, my lord. I cannot go and proceed with the appeal, my lord.
You deposit 50%.
My lord, the 50% deposit only comes, my lord, at the time of adjudication of the waiver application. And not even that, my lord. My lord, your lordship will kindly see, my lord, only one thing, my lord, only one thing.
Stop the copy thereafter.
My lord, only one thing, my lord. Your lordship only bears with me for a moment, my lord. But there's a supplementary affidavit I have affirmed. My lord, kindly peruses this, my lord. I was scheduled to make over payment. Kindly comes to, my lord. There's also a pleading in my revisional application, my lord. Paragraph 6 onwards, my lord, 5 and 6, my lord.
No, what is the dues?
My lord, I tell your lordship, my lord.
What is the dues amount?
My lord, I was supposed to make EMI payment of my housing loan. My lord,
You failed.
No, my lord, I tell your lordship,
You have
my lord.
failed.
No, my lord, my lord.
Section 30,
My lord, there was
14 started.
My lord, there was a temporary deficiency of serving the EMI. I was supposed to, my lord, kindly bears with me for a moment. I've taken the pleading, I the statement.
What is the dues amount?
My lord, at present there is no dues.
Without dues, they have started proceeding.
My lord, I tell your lordship. My lord, I tell your lordship, my lord. My lord, when the 13-2 was issued, there was a temporary deficiency, my lord. My lord, I've taken that in my pleadings. I've annexed the statements of accounts. My lord, I am staying there with my 2 children who are autistic and paralyzed. It is not a case I'm a school teacher. It is not a case I've defaulted. There was a temporary deficiency. As per the RBI circular 4.5, temporary deficiencies are curable.
No notice was served under section 13.
My lord, notice was served. I tell your lordship, I preferred a section 17 application. Notice was served. They preferred a section 14 application before the DM. I preferred a recourse. Now, my lord, I was scheduled to pay EMIs. I failed in paying a couple of EMIs.
You have to pay 50% of the dues amount. What is the dues amount?
Now, my lord, I'm extremely grateful to your lordships. Kindly come to my supplementary affidavit, paragraph 5 and 6.
5 and 6.
My lord, kindly comes to that, my lord. Paragraph 6, my lord, kindly sees, my lord, this is a sanction letter. I have made a table for your lordship.
Where is the notice under section 13?
My lord, I'll show your lordship the notice. I
come to the notice first.
I tell your lordship. Notice my lord, your lordship is looking at the demand notice. Before that, my lord, I'm only pointing out one thing, a query which has fallen from your lordships. That is, my lord, what is my total dues today? My lord, I was scheduled to pay EMI. Kindly comes to paragraph 6.
No, I'm not concerned about the EMI or anything else. I am concerned about the notice issued by the bank.
Grateful, my lord. Kindly come.
Where is that?
My lord, kindly comes to. My lord, the dues have been paid. I was scheduled to pay 19 lakhs. I have paid 20 lakhs.
If you have paid, then why they have started proceeding under section 13?
My lord,
or
I tell your lordship, my lord, there was a temporary deficiency in paying 2 EMIs.
Stop the copy, then come.
My lord, kindly, my lord, bear with me for a moment. My lord, kindly seize the notice once, 13-2 notice.
Where is that? I'm asking you again and again. You are not placing the notice.
At present, the current use is 2.10
13 का बात करो. My lord, at present, the current dues is 2.10 lakhs.
How
I'll pay
can I know?
statement next year.
My lord, I have annexed the statement. Kindly seize, my lord.
Supplement.
Your statement will not solve the problem.
My lord, the statement by the bank.
Where is notice under section 13(2)?
I'll show your lordship.
Position notice.
You have not annexed.
Yes.
My lord, kindly comes to my lord. Kindly comes to my lord. Page. My lord, kindly comes to my lord, page 200. This is a possession notice. This is the notice given after 13(2).
Page number
My lord, page number 200.
200.
My lord. There is a 13(4) notice read with rule 8(1). This is a possession notice. My lord, kindly comes to the third paragraph, third line. Second line. Third paragraph, second line. These paragraphs are not numbered, my lord. It's a due of 11 odd lakhs claimed by the bank. Now, my lord, the issue is the overdue amount is only 2.10 lakhs. I'm ready and willing to tender that amount. And my EMI, which I have defaulted, is only a couple of EMIs. The total EMI payment ought to have been 19 lakhs. I have pleaded in my application as well as supplementary. I have paid more than 20 lakhs. In addition to that, my lord, I have got no recourse in appellate authority, my lord.
This notice was issued in the year 2024.
My lord.
Thereafter, further interest added.
And I have paid for.
My lord, I have paid further. They have attached my salary also. I have paid further. My lord, I'm only on one issue today before your lordships, my lord. My lord, today I have the EMI total. It was an EMI loan, housing loan and top-up loan. Your lordship will find that in my pleadings. I'll show the paragraphs also. The total EMI of both the loans clubbed together comes to 18 odd lakhs. Your lordship peruses only 2 paragraphs.
No, you
I
pay
have paid 20
50%
lakhs, my lord.
of the dues amount.
My lord, the total dues amount, I tell your lordship, the total dues amount is 11 odd lakhs. My lord, this is a recall of the entire facility. I was scheduled to pay EMIs by month.
No.
Now, my lord,
When section 13 was issued, you have to pay 50%. 50% thereafter, your application will be admitted. Otherwise, difficult. Either
lord,
you solve the copy, then come.
my lord, in the meanwhile, I cannot go before the appeal court, my lord. I cannot go before the appeal court. Appeal court is not in session. My lord, in the meanwhile, if I'm dispossessed, my lord, I'm staying there with my 2 children. One is autistic, one is paralyzed.
Maybe.
My lord, only, my lord, protects me till the time, my lord, I can go and prefer a recourse, my lord.
Lord, one more point, Lord, I'm sorry, but one more point which is more pertinent to indicate that one is what is the due amount, what is the 13 amount, and the other aspect is what is the overdue current amount. The current overdue amount is 2.10 lakhs. I have written to the bank yesterday itself that I will pay off the 210 lakhs. My account from NPA will become
You
PA.
pay that amount
have,
and will come. Where is the
Lord,
problem?
Lord, kindly consider
did
Lord,
not pay.
annexure B at supplement once, my Lord. Only once thereafter, Lord,
I have
what shall-
already passed the order.
My lord, item number 13, I was praying before your lordship to place this matter on the regular bench, my lord. Item number 13.
You are for the petitioner.
And for the petitioner, my lord, I need to take an instructions, my lord. My lord, this is an expeditious disposal matter. I need to take an instruction with regard to, my lord, pendency of any interlocutory application with in that matter.
There is pending.
My lord,
Application is pending.
I understand that is pending, my lord. I need to take instruction with regard to the orders passed in that.
Still appearing on behalf of the petitioner. If there is interlocutory application
Yes,
pending before
if it is there, my lord,
then it is very difficult to pass.
I understand. That is the reason, my lord, I need to take instructions with regard to
I think there is some dues.
No. There is no, in respect of the dues, I do not think there could be any because the wife is earning more. He is a senior IAS officer, a secretary rank.
So this can be disposed of by directing the trial court to dispose of. Where is the problem?
No.
My lord, I am appealing for the petitioner. My lord, plaintiff is the petitioner. My lord, in a suit for declaration of title, amongst other relief and permanent injunction. Now, what happened, my lord, here is, my lord, plaintiff being the absolute owner of the property, my lord has appointed, my lord, a person.
You have filed the title suit.
I have filed a title suit. Now, my lord, the gamut of the suit is, my lord, is important here. My lord, why I tell your lordship, my lord, the plaintiff appointed a person, my lord, as a caretaker in the property. My lord, the caretaker, my lord, inducted a tenant, namely, my lord, who is the defendant number 1 here. Now, my lord, the tenant, my lord, mortgage the property with the defendant number 2 financial institution.
How he can?
He cannot.
No,
Now, my lord,
how he can?
Absolutely, my lord, that's my point. My lord, I file a suit because he, my lord, disputed my title. My lord, I filed this declaration suit. Now, my lord, in that declaration suit, my lord, I prayed for an injunction, my lord, not to alienate encumber the property. My lord, court refuses the injunction, my lord, by the impugned order. My lord, if my lord takes up the impugned order once, that is, my lord, 25th of September, my lord, 2025. My lord, where the court says, as financial institution is involved.
SARFAESI Act is involved.
Yes, my lord, now, my lord, the law is settled.
You are the owner.
I am the owner. My lord, I am not the borrower.
Who has mortgaged the property?
Defendant number 1, who is a tenant. So therefore, my lord, I am entitled to an injunction. My lord, now Supreme Court has settled it. Our honorable divisional bench has settled it. In this type of matters, injunctions will be granted. My lord, this is the, my lord, judgment of our honorable division bench.
You saw and come.
My lord, in the meantime, my lord, if they, my lord, encumber the property.
Either you go before the tribunal.
No, my lord, I have filed a suit, and civil suits are maintainable. That the honorable Supreme Court has also held.
You solve the copy and come.
My lord, kindly appreciates, my lord, kindly takes note of this judgment. Kindly takes note. My lord, why I tell your lordship, my lord? I know, my lord, this would be troubling, my lord, my lord. My lord, here also, my lord, a co-sharer filed a civil suit. And, my lord, other co-sharers mortgage the property.
Now the law is settled. You go
So this is the latest, my lord.
You
Honorable Supreme Court kindly looks into this. Honorable Supreme Court 2025 has passed this. And relying upon this, my lord, our division bench has passed this in 2025.
My lord, may I have your lordships, my lord? My lord, this bail applications, my lord, that have been given to your lordship, my lord. Will your lordship have your lordships to take up the matter at 2 p.m., my lord? If the bail
I will
application.
adjust all the civil revisional application thereafter I will take. There are how many matters remaining?
There is no urgency whatsoever in the matter. It's an appellable order.
Next matter, are we doing it? I'm reading, Mr.
Okay, I will take up at 2 p.m. revisional applications. Thereafter, I will take up.
The bail applications, my lord. Bail applications.
Your lordship will take the bail application.
The lordship has been pleased to pass over.
Without certified copy for moving today. Okay.
My lord,
one humble prayer with regard to the last matter, my lord. My lord has made it returnable on the regular bench. My lord, I will serve by tomorrow. Let it be returnable on 16th.
Why?
Because
I have already heard the matter.
yes. My lord, I am not only saying, my lord, kindly makes it returnable on 16th. I will serve by tomorrow.
No.
My lord,
I have already passed the.
But after the civil revisional matters, my lord will take up criminal matters which have been mentioned or the regular list. We
Means-
mentioned few matters because on the ground
Matters I will take up at the last.
the mentioned matters. After
I will
4
take
o'clock.
up, yes.
Grateful to you. Extremely grateful.
Yes, sir. Have you seen the notice issued by this court? Only extremely urgent matters, civil revision will be taken up because there are several bail applications.
But I am for the respondent. I also appear
My
for
lord,
So I am
I am
keeping
for the petition, my lord. The next matter, my lord, is extremely.
today.
item number 5.
I am keeping not today.
My lord will put it in the regular bench. My lord.
No, I am keeping not today. Let them.
I have some difficulty. My
You pray for time on that day.
5th of September, the order was passed regarding an expulsion.
Whatever maybe I am not taking today.
My lord,
Okay.
Let it be posted at the regular
No,
bench.
no,
My lord.
not today. Only. Next, item number 5, not
There
today.
is no
I'm not
urgency
in 5, my
whatsoever.
lord. I made a mistake.
Not
I'm
today.
not in 5.
Not 5, my lord.
Next.
Let it put it in the regular bench. My lord, 16th, I have some.
Yes, 15, item number 15.
15, my lord.
Is there any extreme emergency?
Yes, my lord. There is an extreme urgency, my lord.
Zero
My
urgency
lord.
and appeal lies before the learned district judge.
No, learned district judge, my lord, is not taking, my lord, these matters. My lord, there is extreme urgency. My lord, I am, my lord, for a set of, my lord, limited liability companies.
And my lord, the district judge
My lord,
is.
maybe, my lord, start.
It is. My lord, will kindly
My
see.
lord, it's an order without jurisdiction.
Kal ke aache,
Criminal matter.
15th it's also there, 17th is also there.
Only for criminal.
My lord, it's an order, my lord, wholly without jurisdiction.
Your lordship, lordship is aware even urgent civil matters are taken up. Your lordship is aware that urgent civil matters are also taken up.
Notification does not say. No, kindly go into the minutes later on. My lord, a statement made in the petition that, my lord, the appeal court is not there. When my lord lordship is looking into the notification, the appeal court is there. Now, my lord, today, what they are trying to do.
No, if it is applicable order, then why you are moving this application? You see the notice.
No, it's not.
The notice.
Feigning ignorance will not
Before
do.
the district judge. You move before the district judge.
Yes.
You move before the district judge. The applicable order. Here is already notification is given.
No. Kindly not, my lord. Kindly not. This should not be allowed. This forum shopping, my lord, should not be allowed. Yes.
No,
I have taken a point.
Please tell me whether it is appealable order or not. So, if appealable order, when there is a notification,
For vacation only, my lord, passed by your lordship's coordinate bench, when this has been dealt with.
when there is no session or
That's
there is
true.
no, but the notification is given. Notification, you go through the notification. You go.
No.
Milord, may I say something?
Not today. Not today.
Yes, let it be not today. Let it be not today. Let it be not today.
Before the regular
No,
basis.
because
Kindly, my lord.
Milord,
Kindly
I have
not
a
do that.
227 which is coming up on
Same
16th.
submission. Don't
This
waste.
is not submitted.
Don't waste time because I have to hear the bail
Let it be
application.
not
Several
today,
bail
Milord. Let it be not
applications
today.
are pending before.
16, my lord, I have difficulty, my lord.
No,
This
my matter is anyway
Not
listed on 16th. Yes, great.
item number 14.
Yes, 16.
15. No. Item number 15.
This was 15. This was
15. Okay. Not today. 16.
Milord, I have also not received a copy in 16. I have also not received a copy. I'm an impleaded defendant. I have not received a copy.
Item number 16.
Let him serve. Let him serve and come back.
So far as item 5 is
You are appearing. Where is the problem? For those who are appearing, he will serve. Next.
Item number 5 is
Next.
concerned, my lord,
My lord, several are outside jurisdiction. I've also not received a copy.
my lord, so far as item 5 is concerned, my
Let
lord,
you serve, then come. Affidavit of service. Affidavit of service be filed on the urgent.
so far as item 5 is concerned, would it be a lordship's pleasure that at the request of the
I am calling the item numbers. Extreme urgency.
Extreme urgency, regarding the the petitioner is aged about 78 years old. He prayed for the transfer of the from the Uttar Dinajpur to Dokhin Dinajpur. Order has been passed, my lord, the Uttar Dinajpur.
Not urgency. Not
This was
urgency.
direction to
Not
serve.
urgency. Today I have to deal with the applications. Not today.
I was only inquiring out one thing whether it's possible. But in the Alipur court, where your lordship, they have shown a notification that it is available, the bench is available. And your lordship has directed that the matter will appear on the next day, not today. And may I just request your lordship to follow?
I have not passed any order. I just keeping not today. 16th you move. You mean no. Why should I pass order?
Notification.
No, there is no notification.
On that day you submit both the side before the court. Both sides submit. 18 item number 18 who is appearing for the is there any extreme emergency? If emergency, then only you move. Otherwise, I have to. What is the urgency?
Construction, Lord, is coming up at a lightning speed over a joint property.
Oh, construction.
Construction, Lord, over a joint property, Lord, in violation of injunction order. If I may just show, Lord, kindly give me 1 minute's time.
It is not so urgent.
The construction on a joint property, Lord, taking advantage.
There are several matters pending for bail. They are most important and they are urgent.
Only for the period till the regular
Illegal
bench.
construction that may be demolished after 2 weeks or 3 weeks. No
This is a joint property, Lord, equity will be claimed by the joint owners. Lord, equity will be claimed by the joint. Kindly
Illegal construction that can be demolished. That can be demolished.
Kindly put us till 24th. 24th. Lord, I shall come back before the regular bench and Lord, seek on 24th. Lord, kindly put me till 24th only.
24th?
24th of October, my Lord, when the regular bench.
Let the matter appear before the
Final matter is that
is there any urgency?
Yes,
What is the urgency?
urgency is that the the suit is pending before the concerned junior division and also file suppressing the pendency of the suit and the appeal and also the order injunction passed by the appellate court. The same party being the plaintiff opposite party number 1 file another suit and obtain the order of injunction, my lord. Injunction was there. The question is
What
that
was the injunction or
injunction in the same form?
Same form, so where is the urgency? Both
Urgency
parties
is that
should
my
maintain.
one injunction order.
Both parties should maintain that interim order.
No, my lord. Injunction
Earlier or
injunction
even
was
later.
passed by the appellate court. Suppressing the order of appellate court's order, injunction, they file the same suit, another suit, and file the order of injunction.
File an application.
And I only pray for expeditious disposal of the injunction application. Nothing more than expeditious disposal. In accordance with the provision order 39 rule 3A.
petitioner, my lord, order passed by the DRAT, dismissing my appeal on the ground of locus standi. Now, my lord knows section 17 of the Surface Act. Section 17 of the Surface Act, my lord, envisages that any person, including a borrower or a guarantor, may make an application before the Surface Court under 17. My lord, I am an agreement for sale holder. My lord, I'll take my lord to the impugned order for once. Kindly take the impugned order.
You have filed the appeal.
I had preferred the appeal. My lord, I filed the section 17 application before the DRT. The DRT dismissed my section 17 on merits. I now appeal before the DRT under section 18. By the impugned order, my lord, the DRT dismisses my appeal, saying that I have no locus standi. Kindly seize, my lord, kindly seize.
So what
Page
is your
15.
locus standi?
Yes, my lord. I have a prior agreement for sale in respect of the same property, in respect whereof, my lord,
Registered.
unregistered.
So,
My lord, kindly bears with me.
you swap the copy.
Kindly bears with 2 minutes. 2 minutes bears with me. 2 minutes. My lord, it's an unregistered agreement in respect whereof, my lord, an arbitration reference is going on. The question of, my lord, inadequacy of registration, non-registration has been decided by the arbitral tribunal, my lord. The court records that there's an arbitration going on. Yet, my lord, negates my claim on the basis that it's an unregistered agreement. I cannot look into it. Now, that is not the law, my lord. Your lordship's court has held otherwise. Those are judgment of this. Kindly seize. Kindly seize this judgment, my lord.
Ne-
My lord, page 3 will kindly seize. The question of registration only comes into question, my lord, when there's a transfer of possession. My lord, kindly seize 3rd page. The finding of the learned trial judge. It's a judgment, my lord, by a division bench of his honorable court, my lord. Kindly seize, my lord, page 3. I am on the issue of registration, my lord. Kindly seize. The finding of the learned trial judge that enforcement of an unregistered agreement for sale by filing a suit for performance of contract is not maintainable, cannot be accepted by this court, as registration of an agreement for sale is required only in case where possession of the property is given to the proposed purchaser.
No, agreement for sale was prior to mortgage.
Yes.
That was not registered.
Not unregistered, but in respect whereof, my lord, an arbitration proceeding is going on.
Maybe.
My lord, but he cannot throw me out of
I
the
am not passing any interim order. If you want, I will serve the copy to the other side. You serve the copy to the other side.
Let them not create in third-party interest. My lord, that was the injunction of the
No,
kindly seize. I was enjoying that order right through the appeal, my lord. I was enjoying an interim order restricting the defendants, the respondents number 6 and 7 from dealing with the property. That's the limited protection I seek even here, my lord. My lord, kindly seize the finding of the appellate tribunal. He says I have no locus standi.
No, tribunal has rightly held.
No, my lord, kindly visualize section 17 of the act, my lord, says any person including borrower.
The
And the question, my lord,
tribunal has well discussed.
no, my lord, it might discuss, my lord, with the deepest of respect, my lord.
On registered,
My lord,
everything discussed, and
my lord,
thereafter
with the
rejected
deepest
us.
of respect, my lord, deepest of respect, my lord, if after discussion, the learned appellate court records of, my lord, a finding which is erroneous, my lord, the revisional court has a right to interfere, my lord. With deepest of respect, my lord, kindly seize. I have been thrown out on the ground of locus standi. No, my lord, section 70 is very clear. Any person, including borrower, my lord, I have an agreement.
What is the provision if the appeal is dismissed? Only revisional application?
Only revision, my lord. 227. And this, my lord,
there is no further appeal?
No, my lord, no further appeal. DRT, DRAT, High Court.
You have appeal under section 17?
Section 17 before the DRT. I lost section 18 appeal before the DRAT. Now, DRAT says my appeal is barred because I have no locus standi. Lord, kindly, kindly seize. Even the Supreme Court, even the Supreme Court says, even an unregistered agreement for sale creates a right in personam. My right of a person holding an unregistered agreement for sale is to have it enforced.
Your property has already been mortgaged by the by the original owner.
No, so, that's not the issue, my lord. My arbitration was prior in time. Kindly visualize this.
When the mortgage was taken?
The mortgage, the 13-2 notice, was. The 13.
No, when the mortgage was taken?
The mortgage was 2007.
7.
And my agreement for sale in 2006.
6.
Yes.
Until then, you are sitting tight.
Yeah, because arbitration is going on. My lord, the arbitration is going on.
When arbitration started.
My lord, 2010.
So after 2007.
That arbitration, my lord, kindly visualize this. Arbitration has been,
hard.
my lord, kindly.
Hard.
Arbitration, my lord, has been directed to be conducted in terms of the order of the High Court. The High Court directs the arbitrator. The High Court appoints arbitrator to arbitrate. Well, kindly cease, well, I'll serve and come back.
My lord, similar matter, my lord. Item 29, injunction was passed on 25th September.
Expeditious disposal of temporary
Order
application.
39
Yes.
rule 1 and 2, my lord,
A-
it is
and-
appealable order.
And no,
I
I am
will
not
appeal on
challenging.
behalf of the
I am not
opposite
challenging
party.
the order of the
This is
interim
appealable order.
injunction. I am only pray for expeditious disposal of the
No,
injunction.
can't be, my lord. This is an appealable order. Order 39 rule 1 and 2, my lord, order has been
Challenging
passed.
that order.
No, temporary injunction can be disposed
Yes,
of.
but
Where is
True.
the problem?
True, my lord. The only thing, my lord, this is an
You
appeal.
have solved. You have solved the application.
Not served.
So how you
I intend to appear, my lord, because I have seen the cause list. I have
Injunction
seen the cause list. My interest is there, my lord.
dispose within that.
देखो,
My lord, this is an application. My lord, I have
any urgency?
yes, urgency is that for 8 days, my application under Order 39 Rule 7 has been pending before the learned trial judge, holding the local inspection. Controversy is that I am claiming the entire possession of the suit property. Plaintiff also claiming that the entire property
Let the
at their
commission
possession.
be held.
So,
Where
so
is the
my
problem?
application should be heard within the time, my lord.
No,
8
that
days
is-
has been elapsed, my lord. Only expeditious disposal. 8 days has been elapsed. 8 days has been elapsed according to the
Is there
status.
any order you have challenged?
No, I am not challenging the order. I am only direct the trial court to dispose of my application under Order 39 Rule 7 within the 1 month.
When is, when is the next date fixed?
Next day, the 3rd November, my lord. 3rd November. Page 116, my lord. Kindly see, page 116 is the status information. Status information 116.
The petitioner
my lord, order of the DRT. Now, what has happened, my lord? They have taken possession. I have no problems. Possession has been taken. Now, my lord, they are removing the goods. The defendants, my lord, are removing the goods from, my lord, the premises of which they have taken possession. Now, my lord, that is not countenanced under law. My lord, I take out an application, my lord, kindly sees. The application, my lord, is at page.
Your possession has
150.
already been taken up.
My possession is taken, my lord, I have no qualms. I'm challenging that. But my goods are inside. They cannot remove all the goods. They cannot remove the goods, my lord, in a clandestine manner. That is precisely what I am on. Kindly seize my application, page 152.
You have given the details of your items.
No, my lord, I have sought for an appointment of a special
Without,
officer.
without
My lord,
giving your
my lord,
items, what was the
my lord,
item
may I put it this
present
way?
in the
My lord,
premises? How court can direct?
I bow down, my lord. I had sought for an appointment of a special officer. Now that application has been kept pending. It's not been taken up, my lord. Innocuous spray, my lord, on 24th when the DRT reopens, kindly directs the DRT to take up this application on 24th as a put up. That's the limited, my lord, order I'm seeking, my lord. Kindly seize. My lord, kindly see my innocuous spray at page 165.
Page 165.
Yes, my lord. This is the interlocutory application filed in connection with the section 17 application. The application starts at 152, my lord, and at page 165 is my innocuous prayer. Sees, my lord, appointment of a special officer to visit the property and make inventory. Because whatever I say will not go down well with them. Whatever they will say will not go down well with me. So it's better I appoint someone. And my lord, that they are removing is at my pleading, my lord, at page 164, para 36.
When is the date fixed?
But the date has been fixed on 30th of October, my lord.
Where is that?
My lord, kindly seize, my lord, the impugned order. My lord, kindly seize the impugned order, my lord. Order dated 23rd of September 2025. This was the day on which, my lord, torrential rainfall, my lord, had paralyzed the entire city, my lord. The urgency is this, my lord, they're removing goods, my lord. They're continuously removing goods, my lord. I'll be left nowhere. If at the end of the day, my lord, I'm successful in my section 17 application, I'm nowhere. My lord, seize my pleading at page 164, para 36. I am only, my lord, let them not remove the goods and kindly take up my application. Limited order, my lord, I'm seeking, my lord.
Have you given any list of those articles?
My lord, I have, but my lord, the problem is, my lord, now it's under
Have
lock
you
and key.
annexed that?
How can I, my lord? It's under lock and key. I cannot enter, my lord. If I enter, I'll be hauled up for trespass. How could I, my lord? That's why I said, my lord, appoint a special officer. Appoint a special officer, and till that time, do not remove. Innocuous play, my lord.
The date is fixed on
30th of October, my lord. Now, what is happening, my lord, in the Interim, they're removing goods. My lord, I sought to move it on 19th. It was put up on 23rd. 23rd, my lord, there was torrential rainfall, my lord, and thereafter no date. In this 1 month, they've already started to remove goods, my lord. On 24th, let the DRT pick up the matter, and in the meantime, restrain them from removing the goods. My lord, simply innocuous spray, my lord.
And you have challenged the order 23rd September.
Yes, yes, my lord. That was my urgency, my lord. 23rd, if there's a rainfall, my lord, with this urgency, the learned judge in tribunal could not have posted it on 30th of October, my lord.
Please come. You are the owner of the property.
Yes.
Earlier you were owner.
Yes.
You took the
The
loan.
movables, yes, the movables are my property. Whether they are mortgaged or not.
File an application under Article 220.
I'm grateful. My lord, within a week. I'm so grateful.
30th within a week.
And within a week.
Within a week thereafter.
Within a week.
30th October.
October. I'm so grateful, my lord.
Disposed of it.
By 30, I'm for the petition.
ওটা লিস্টে থেকে ডাকছেন, লিস্টে থেকে ডাক No, I am taking over the matter serially. Nobody appears. Nobody appears on.
of case under section 303 and subsection 5 of the BNS and under section 302 of 34 of the Indian Penal Code. Malada, no circumstances has been proved against this petitioner, Malad. I am the close friend of the principal accused. Malad, Noyan Bittar is the principal accused. He was arrested and he is in custody.
This is renewal of bail or first time bail?
First time, my lord. My lord, 40 days I am in custody.
This matter was filed on 3rd of October. It was first taken up. Thereafter, no, 25th of September. Thereafter, 3rd of October. The matter was dismissed for default.
Thereafter restored, my lord.
Now before the vacation bench.
Okay, no problem. I am hearing on merit. 240 days.
40 days, my lord. I am
14 days.
40. 240, my lord.
So this is a case where this petitioner had a relationship with one lady.
My lord, no.
Yes. The lady has been murdered.
My lord, kindly see the statement.
Children, minor children. Does it kindly see?
My lord, kindly see the statement.
Materials.
My lord, kindly see the statement. Noyan Bittar is the, my lord.
What's it? Only two. This petitioner and another, they entered to that effect. The other witnesses, what's it? Kindly says. Page 13.
Is there any eyewitnesses?
No, my lord, no.
Circumstantial evidence.
Circumstances.
This petitioner and another, who is his friend, they entered into the house of the victim.
Last seen together.
Last seen together. Apart from that,
My lord, kindly see the statement.
Please, I have heard you.
does it kindly see page 13?
Yes.
Saw the accused to enter in the house of the victim. Thereafter page other and date has been fixed for settling date of trial. November 2025 for settling date of trial.
My lord, not trial, not comments.
Not comments, date has been.
It is
Charge
submitted.
was not framed, my lord.
Submitted.
Your Lordship. Madam for the petition.
Defective complaint.
302 of the Indian Penal Code. I'm reading by prayer for bail. The prayer for bail of the petition number 1 was lastly rejected, my lord, in the month of January 2025, wherein the prayer for bail of the petition number 2 was rejected in the month of December 2024. Now, my lord, out of my lord 25 witnesses, my lord, total one witness out of 23 witnesses, one witness has been examined as of now, my lord, in part. My lord, the petitioner number 1 is in custody for 2 years, and the petitioner number 2 is in custody
Whether
for.
any application rejected by High Court or
Yes, I'm renewing my prayer for bail, my lord. That is why, my lord, I was submitting the
you
prayer
have
for bail.
annexed the order?
Yes,
You
my lord.
annexed the order?
The petition number 1, last rejection, is at page 8 of my application. আমার আর একটা কপি আছে দেখি সব পেজে।
Yes, 8 was
I was
rejected.
Article 21 I was harping upon, my lord, on the score of Article 20.
How long you are in custody?
2 years, petition number 1. Petition number 2 is 2 years, 2 months. 2 years.
Let the report be called for. Report be called for.
A progress of trial is required. I'm harping on Article 21.
What is the stage? What is the stage?
PW1 has been examined in part.
Yes.
Day after tomorrow, my lord. Tomorrow, day after.
It is not possible. The petitioner renews
Lord, in this matter, my lord, two
Lordship, I have
accused were
served
granted bail,
notice.
my lord. My lord, the Supreme
Lordship,
Court
I have-
cancelled the bail. The other matter, the Supreme Court cancelled the bail.
That will decide on the merit.
That
That will decide on the merit.
That is why
Lordship, I have served the notice that the matter will be moved before the vacation bench upon the learned advocates appearing. Now, Lordship, this is
I'm for the defect. But I'm for the
now, Lordship, kindly consider the incident of January, February of 2024. No, Lordship, this is 84
For
days.
defecto.
Lordship, 84 days I'm in custody. The incident of January, February 2024.
64 BNS.
376. Yes. Now, Lordship, the 64 I am in custody, 84 in
Let
custody.
the CDV call for.
Lordship, 84 already, no charge sheet filed.
So without CD, I can grant bail.
Kindly consider the documents I have annexed.
Without CD, I can grant bail.
Lordship, 84
What
I
you
am
are
in custody.
submitting?
Lordship, I have served notice. Lordship, this is
Maybe.
their fault.
CD is required for disposal of this case.
Lordship, 84 I am custody. This is the incident of 2024.
Affidavit of service filed.
But I am for the petitioner, my lord. Lord, I am in custody for 8 months. Lord, this is the first time I have come before your lordship, Lord. The petitioner was having a amorous relation with Lord the lady. Lady is a married lady having a child. Husband come to know about the relationship. There is a quarrel between the husband and wife. Then wife takes poison and commits suicide at the husband's house. Lord, I am in custody for 8 months. Since, Lord, I was having a consensual relationship with the lady. Husband is not an accused. And Lord, more surprisingly, your lordship would kindly see this document for a second, Lord. The husband comes up and lodges the complaint, but kindly see who has brought the lady in the hospital. Lord, it is stated, Lord, as per brought by the person's, Lord, neighbors. Husband even does not try to save the lady. Lord, your lordship would kindly have a look to the injury report, Lord. This copy has been supplied, Lord.
Who is appearing for the state? CD is there.
Having a child, Lord, the husband used to work. It was a consensual relationship.
This is the suicidal note and the time.
Full thing, full thing. Suicidal note of that victim. ना काचे प्रोफॉर्मा
My lord, this is not relating to the POCSO or anything. I have served the state. It is in case of 302. These persons not named in the FIR, and in 164 statement his name not appear. I have I mentioned this matter.
My lord, I am for the petitioner. My lord, case under section 498A 302 34. That is, my lord, case under section 85 103 1, which is 498A and 302 and 35. That is 34 of the IPC. My lord, I am in custody. I am the husband. I am in custody for 96 days as on today. My lord, yes, that is 302. And 85 is 498. My lord, marriage took place 20 years ago. There has been no complaint from any quarter in these 20 years. 2.5 years, for the last 2.5 years, my lord, she was, from 2019, she developed a mental problem. I have annexed the medical papers. I have all the other medical papers as well, all with me. I could not annex everything and burden your lordship. My lord, what is the cause of death? She has probably consumed poison. We have no idea how did she die. The state will be able to address your lordship. We took her to the hospital. But
my lord, kindly have a look to the two independent witnesses 164 who are the neighbor of the husband's residence. Kindly see, my lord, page number 164 and 168. First, your lordships, kindly see 164.
My lord,
after becoming Panchayat member, my lord, what happened in his lifestyle? See, 164. Yes, 164 statement of in page number 164. These are all not relative witness, these are independent. Page 167. Another one. Now, my lord, kindly come to post-mortem report, which is in page number 83.
injury part. Had it been consummation of
Maybe, I am not sure, but police is saying death by strangulation.
anyway, my lord.
Police is saying in the charge sheet death by strangulation.
PM report, my lord.
Father is saying death by smothering, by pressing the pillow.
My lord, kindly see, my lord, injury report, my lord. That is on PM report.
Doctor has sent the viscera and reserved his opinion.
My lord, one bruise 5x25 reddish in color present in inner aspect of lower lip. That must be, my lord, fist and blow, possibly. my lord.
Lower lip.
And second one is one pattern bruise.
Kindly see
pattern present.
my lord, let the prosecution say what is this case.
Consider these
The police is saying in the charge sheet death is by strangulation. Death is by strangulation.
My lord, PM report says so, my lord.
Huh?
Yes.
Many, my lord, it is kindly see the charge sheet. It is strangulation, death by strangulation, and the father says death by smothering by pressing the pillow. Yeah, and my learned friend places before your lordship the case that there is rib. I'm in custody for 96 days.
That is my submission.
My lord, rib. After 20 years of marriage. After 20 years of marriage, my lord. Charge sheet submitted.
My lord, since July, my lord. 9th July 2020.
96 days as on today.
চিঠিটা দিয়ে দিয়েছেন দাদা? হ্যাঁ।
Item 7, my lord, Mr. Nag is appealing.
My lord, am I audible, my lord?
This matter,
My lord, I am audible.
court has
My
not
lord,
but these matters relates to regular bench matter, and state has not been.
yes, no, my lord, it has been notified. I have taken leave of the regular bench. My lord, kindly
Sir,
see
I am
page
told that
42. I am claiming bail on parity.
Ask them to show the note that they have served the state, my lord. Kindly show, my lord.
My lord, when the matter was mentioned, state councils were present. Lot of matters has been mentioned and come up in the list.
My lord, in a bail application, my lord, the application is served, and my lord, thereafter the.
My lord, he doesn't know that in this.
My lord, we have served, my lord. If had it not been served, my lord, it cannot be filed only.
No, that is a different thing. This is matter pertaining to regular bench.
My lord, a bench has, my lord, if my learned friend.
To move the vacation bench. Now they have to notify the state. Have they notified the state? How will the state know, my lord?
From the list. It's a public list.
Nothing, we have nothing. Regular bench, my lord. My lord, this matters regular bench.
No, my lord, kindly keep it next way. They are now notified. How can they say that they have not been notified?
My lord, I'm in custody for my lord, 317 days, my lord.
300?
1 year. And I'm playing on parity.
More than 1 year, my lord. No, how more than 1 year? And co-accused has been granted bail. my lord.
Still you produce 60.
Very, very difficult because the time, my lord. Because the day after tomorrow is the vacation bench. Correct?
Yes, I will be there.
But they have to.
Which police station?
I don't know. We are in dark.
Mohestola. Mohestola.
Mahestala police station, my lord.
So Mahestala they should have given.
Counsel appearing on behalf of the
Alright, item number 8, I am appealing for the de facto complaint.
I'm for the state, your lordship.
I'm paying for not to now.
Huh?
Only not to.
Let the matter be placed before
Yes,
the
very
Only not to.
important.
Thank you.
Lordship, for item number 9, I'm praying for not today.
Ten.
My lord, I am appearing for the de facto complainant. If land friend prayed for not today, then before the regular bench, my lord. Each and every day they praying for time, my lord.
counsel appearing on
Place before the regular bench. I am appearing for the de facto complaint.
Number 10, I am with the petitioner, my lord. We are in custody for 10 years, my lord.
10 years.
More than
Section?
my lord. Section 302 is there, my lord.
How many occasions this bail prayer was rejected?
My lord, as far as item number 10 is concerned, I am told, my lord, this is the first time.
My lord, this is the report. My lord, this is the report. The trial is at the fag end. PW 33 is will be examined on the 27th of October 2025. So therefore, my lord, last line, my lord, he is the last witness, the IO.
My lord, item number 13 in today's list is the co-accused person.
And
He
item
had
number
approached
10.
the court before. Yes.
You are moving item number 10.
10, my lord. Item number 13 is the co-accused. He had approached this court multiple times before.
I
This
know.
court, my lord, had specifically directed. There was a specific time stipulated, my lord. On 2 occasions, the court actually gave such directions, my lord. 33 only out of 44, my lord. 10 years in custody.
Yes, but the trial is going. Lordship will kindly peruse this order.
Yes, I have perused the order.
No, this is the order, my lord. This is a co-accused whose bail was rejected, similarly placed. Eta my lord ke din.
Yes, but 10 years.
Lordship will kindly peruse paragraph 4. Eta din na.
At least 10 years.
And they are regularly taking time. On 6th September, they took time. On 17th September, they took time. With the pretext that delay in trial, they will take advantage in the High Court.
My lord, how can we take advantage? My lord, my right to Article 21 is being.
The trial is at fag end. It is not that the trial has not been commenced.
Interim bail at least 10 years.
Why?
No.
10 years, my lord. Lord would say it is not because of the defense. My lord, the delay was.
This is your renewal of prayer for bail. This time.
Lordship will kindly take the report. On the report, it says that the last witness will be examined on the
I have the
27th
status
and
report with regard to the trial.
Item number 11, I'm praying for not today, Lordship.
Item number 13 is same.
My lord, item number 13, I have instructions to take accommodation for this day.
Why accommodation? Similar fate will be there.
Finally, we would like to bring the depositions without because nothing against the one at number 13.
Okay. Item 11.
Lordship, for item number 11, I'm praying for not today, Lordship.
Not today, make it regular.
Lordship, not today, Lordship.
Yes. Not today.
Lordship,
Make it
kindly,
regular bench, Lordship.
Regular bench.
Lordship kindly keeps it on 16th, Lordship. Today, Lordship kindly keeps it on 16th, Lordship. Today I have some reservations.
This is their prayer, Lordship.
Let me record
They
the
do the matter in the vacation bench.
The matter was.
Earlier you had taken a adjournment. (376). Let the matter be placed.
Egarro.
12.
Lordship, I beg to appear for the petitioners. Lordship, there is one rejection of this honorable code in this case. But after that, there is
Renewal of bail.
Lordship,
Renewal of bail.
yes, Lordship, but there is a gross development after that. That is, the case has gone for further investigation under 173(8). That has been allowed. But there is a technical mistake, what as per my
Lordship will
opinion.
kindly ask my learned friend. If this is a matter pertaining to regular bench, how has he informed the office of the learned public prosecutor? This is important. Otherwise, how will he bring?
Let the matter appear before the.
No, how has he informed? Has he notified the office of the public prosecutor? Kindly ask him.
That's why I'm asking him to serve or notify.
No, regular bench, my lord.
Let the matter.
Lordship,
My lord,
then let
Lordship
the
will
matter
kindly
go to
post
the
the
regular bench.
But the brief is somehow misplaced. I cannot find. Could it be on the 16th? I was to do the matter.
Not
but I
today.
couldn't find the brief.
Not today.
Yes,
But I'm for the de facto.
Not today.
Very good.
But and the item number 16, my lord, that was fixed on 16. That has wrongly come up. That item number 16.
16 already recorded there. 16. 15 ওইটা তো হলো ওটা রেগুলার বেঞ্চ 16 not today.
I am for the statement.
I beg to appear on behalf of the petitioner. But petitioner is in custody for 369 days. Charge sheet submitted. Although charge has been framed, but till date my instruction.
What are the sections?
329 subsection 4 of the BNS, that is 448 of the Indian Penal Code.
IPC, can you tell me?
448, 323, 325, 324, 326, 307, 302 of the Indian Penal Code.
Two is also there. Yes.
Yes, Lordship.
How long you are in custody?
369 days.
My lord, kindly see page number 53.
Let him submit first.
No specific role has been attributed to the petitioner's allegations is this, that over this dispute or some old dispute was there. Thereafter, 3 persons asked for a bidding to the deceased for smoking. And thereafter dispute cropped up and thereafter they hit and the person died.
You are present at the place of occurrence.
Yes, yes. But there is no specific role has been attributed to the petitioner.
Lord, kindly see first page number 58. This is his leading statement. After that, I will show the Shiza list. Page 58 first. Now, my lord, kindly come at page number 53.
What is the specific role? Is there any eyewitness?
Yes.
Well, this is the statement of
page 8, page 8, page 9,
the
page
role has been
10,
attributed to this petitioner.
page 12, 13, my lord, one by one. Page 8 first. Eyewitness plus independent. Page 9.
Is Abhimanyu Mandal?
Yes. My lord, trial is substantially progress. My lord, next month, 10th and 11th is the date fixed for examinations of charge sheet witness 1, 2, 3, 4, and 5.
And Lordship, why is the progress? And the statement of one Bapon, who is the independent eyewitness, he has said nothing about me.
My lord, apart from this, Bapon, my lord, kindly see page number 9, 10, 11, 12, 13, 14, 15. These are all eyewitness.
But Bapon is the independent eyewitness.
Yes.
He has not named about me.
There are other independent also.
Kindly says the son was examined.
Specific name is there, sir.
What I did? What is the have I assaulted? That is there in the 164. Lordship,
Lord, the offending weapon recovered on the basis of his leading statement. That is in page
That
number 58 and 53.
Is there any forensic lab report that this is the weapon was used? Any blood stain, anything? I have the copies of the 164 also because copies have been supplied. No specific role has been attributed to the petitioner.
Is there any 164?
My
Yes,
lord,
Lordship.
yes. My lord, page 87.
The Bapon Mondal, who is the neighbor, he has not said anything.
My lord, page 87.
Son has said that they were present. Lordship, kindly see
164 is the
statement of
specific name has been given.
kindly see
Not today.
Not today. Okay, not today.
My lord, 19 I beg to appear for the petitioner. My lord, under section 10 POCSO sees the 164 for
My lord, I am praying for not today. I am praying for not today.
Not today.
My lord, I am praying for not today.
Not today.
Next year.
Same.
My lord, I am praying not today, lordship.
Vacation. I think it will be vacation.
No, no.
After
my lord,
vacation.
kindly make it not today. Learned senior engage in another court, lordship.
Okay, not today.
Deeply honest.
23. None appears on behalf of the petitioner. Let the matter.
There, we have served copy upon the victim, but that has returned back. Kindly make it in the
Let the matter. And petitioner is also directed to notify the
Not today, my lord. Not today.
Why?
Sir, senior has directed to.
Not today.
Kindly fix it before the regular bench.
Please speak loudly.
Before the regular bench, my lord, kindly.
Regular
fix it.
bench. Let the matter be fixed. Regular bench.
But for item number 23, my lord, I was in the next courtroom, my lord. 23, my lord, the state is represented.
23. Not today. Only not today.
But I am
Next.
for the I am paying for not to.
Why not today?
But my senior is engaged court number 8.
Okay, not today.
Same pay. Not today.
29 was similar.
Not today.
We're on behalf of the state.
I am for the. 9 years, 2 months in custody, but my lord, affidavit of service not affected, my lord. Kindly direct state to affect the service, my lord. And my lord, status report be called for.
My lord, this is the case with rape with murder.
Maybe.
My lord, 31 is marked as defective. My lord, it has to be sent to the department. I do not know why how defective it is.
Detective as in.
My lord, in the cause list, it has been marked as defective.
For 33, my lord, for the petition, my lord, I'm praying for not today, my lord.
No, not today. Why not today? Every matter not today.
Learned senior is engaged in another.
Ask him to come. Pass over.
Then regular bench, my lord.
In this way, I cannot adjourn each and every matter.
My lord, learned senior is engaged.
There are so many matters appearing.
For this, my lord, but
Filing matters and then praying for not to. Kindly proceed on the
my lord.
What is the matter about?
Order case, my lord, earlier rejected.
Renewal of prayer for bail. Earlier rejected.
There is a court.
But my lord, there are certain matters. My lord, there are
My
certain.
lord, kindly proceed on regular bench.
My lord, will kindly post it on. My lord, kindly not today, my lord.
Who is appearing for?
My lord, I'm led by Mr. Moyuk Mukherjee, my lord.
He was here.
My lord, he is appearing in another court, my lord.
Yes, that is legal.
Regular bench.
My lord, let it be not today, my lord. My lord, let it be not today, my lord.
Let the matter.
Not today.
Why?
My lord, London Advocate Shivaji Kumar Das engaged court number 8.
What is the matter about?
I have no.
My lord, then kindly make it because এটা কি vacation এ করবে নাকি না regular bench, my lord, kindly make it before the regular bench.
302.
Regular bench.
How long you are in custody? How long you are in custody?
My lord, I have not.
You do not know why you are do not know, and you are
Just I am
seeking for
instructed from my
adjournment.
senior, my lord. I am paying for not today.
One person was released on bail, not today.
My lord, 35, my lord, similar to 14, my lord. Those two briefs are missing, my lord. I cannot figure out. 16, my lord, kindly.
Not
lost
today.
it in court.
Not today.
My lord.
I'm for the state.
My lord, I am for the de facto complaint 36.
Yes. None appears on behalf of the petitioner.
36.
Not today, my lord. Not today, my lord.
No C70.
But
What is the urgency?
my lord, he is the shooter. He is the main. He was there inside the premises. My lord, kindly place it before the regular bench.
Place before the regular bench.
Seven, my lord, I'm for the state. My lord, anticipatory bail of the petitioner was rejected earlier, my lord. Thereafter, my lord, in 2020.
Place before the regular bench. None appears on behalf of the petitioner. Why?
Senior has his legs on court number
What
6.
is the matter about?
My lord,
Ready to send to regular bench. কোথায় গেল রে? এগুলো গেল কোথায়?
Okay, not today.
এইগুলো গেল কোথায়? এই স্লিপগুলো গেল কোথায়?
My lord, not today. Senior.
স্লিপ নেই এখানে।
Already rejected your prayer for bail.
49, I'm paying only days accommodation. Only days accommodation. 39.
Why? Why days
Try,
accommodation?
try the Vishwas is appearing, my lord. He's on his leg in court number.
Okay, not today.
Great.
Regular bench, Lordship. Everybody.
None appears on behalf of the petitioner. Let the matter place be.
On also, my lord, same prayer, my lord.
Regular bench. Regular bench.
Those are not appearing regular.
42 lordship, I'm for the state.
Regular bench.
Same order with defective order হয়েছে না? Defective. Defective.
Lord, I have instruction to appeal for the de facto complainant.
My lord, allegations are 307, 325,
307.
307. was on my legs with the other two.
You wait last.
Kindly makes it not to that one.
40 not today.
40, not to.
Regular bench.
Oh, only not today. I was stuck, my lord. I couldn't come.
No. Already passed order. Your junior, I asked junior, 46. File already gone.
My lord, not today.
File already gone, sir.
My lord, it is very difficult, my lord.
In this way, I have to.
The filing in the vacation, not that I got it from the regular way. My lord,
I will hear today. Are you ready?
my lord,
I will hear. Bring that record.
obliged, my lord. Obliged.
I will hear.
Last, my
You
lord.
inform the state. I will hear.
Obliged.
Item 14 years.
Chairman was not possible today, Lordship. At the very beginning, I told you, my lord, it's not there. Nobody is here, my lord. And the case that is not with me, Lordship.
Case diary is not with you.
Sir, not today. Next day I'll try.
Not today.
Not today.
अच्छा 40 लिखूं तो 40 ना 40 वो आगे
Completed, my lord. Service has not been completed.
तो vacation regular bench.
Not today.
How service can be
Kindly,
completed?
kindly direct the state to notify, my lord.
So one day they can notify. How is it
As your
possible?
lordship, as your lordship, my lord.
44 vacation after vacation regular bench place
44.
before the regular bench having determination after vacation. Next 46. Why?
He is on court number 6.
Forty-six.
Not today because state is not available.
Not today.
My lord, I'm appearing on behalf of the petitioner. The advocate on record himself will appear, and he is not well today with mild fever, and he informed me to take a adjournment. Not today,
Is there case diary?
but humbly requested he has
POCSO,
mild.
6 POCSO.
Regular bench.
Regular bench. Service has not been affected.
number 49, I'm praying for not today, Your Lordship. Kindly keeps it on 16th, Lordship.
Who is appearing for estate? 46, 49,
49.
49.
What could Bakuli's my lord is there?
Okay, not today. Defective order, same order, defective.
Not today, how is it?
50.
Well, if 50 is marked as defective, it has to be sent down to the filing section.
This matter appeared under heading defect.
Not today, my lord. Regular bench, my lord, otherwise.
Regular bench. Regular bench.
It was the similar matter.
Number 53, Mr. Ganguly is appearing, my lord. Kunal Ganguly. My lord, kindly make it not today, my lord. Only not today.
What is the matter about?
My lord, matter about 302 out of 9, 8 persons have been granted bail by this honorable court. Kindly only make it not today, my lord.
Someone granted bail. Someone granted bail.
My lord, my lord. Kindly make it not today, my lord. No, my lord, kindly make it not today, my lord. Kindly.
It is not there.
Regular bench.
CD is not there.
My lord, let them ask to bring the CD, my lord. Kindly.
Which police station? Which police station?
Police station.
Okay, not today.
My lord. Konkar Tola.
Oh, not today.
Number 54, on the ground of Mr. Dhananjay Banerjee, I am praying for not today.
No, not today. Not today. Not today.
I'm not paying only not today.
My lord, because regular bench. Regular bench. Regular bench. Regular bench. They are taking time, my lord. We can't manage. With 2 courts running, my lord. It's not possible.
Only not today.
Oh, I came out of that.
What is the matter about?
302 others who accused are on bail, my lord. Kindly make it not today. Not today, my lord.
They are not similarly placed, my lord. They are. Nah, the corona kolle ajke karo na regular bench karo.
Kindly make it not.
No, my lord, regular bench.
This matter, my lord.
If they are doing it, he is there, my lord. Let him do.
No, you cannot direct.
My lord, senior incapable.
You cannot direct.
NPAs senior. That's my lordship.
Oh.
Yes, not today.
Not today, my lord. Grateful.
I'm praying for not today.
I am the defective complainant, Lordship.
Sir, I am for the
I am for the defective complainant, Lordship.
56.
I am for the petitioner.
Yes.
I am for the defective complainant.
I am for the petitioner, my lord.
CD is not available.
56. Oh, sorry, my lord. I am 66.
56 not today, lordship.
CD is not available today.
Then not today, my lord.
Praying for
I
not
am there, my lord. I am there in the 56, my lord. But the CD is not there, then it not today.
Complainant.
64 আমি ডিফ্যাক্টো 64
I am for the petitioner, my lord.
57.
I am for the petition.
After vacation.
Regular bench.
What is the matter about? Murder. Murder case.
No, my lord. 307.
Nobody is appearing on behalf of state.
The state is not there, Lordship. My lord, it is not there.
Not today.
So after vacation?
No, no,
Not today.
not
Not today.
same prayer. It 58.
After vacation, Lordship, because
Sir, I'm ready. Yes. Not today.
58 is ready? Yes, move. CD is there.
no, Lordship.
Not today.
হয়ে গেল
58. 57, 58.
59, 14 কি?
I am ready. 59.
Effective.
Lordship, defective has been already corrected. Lordship.
What was the defective?
Lordship, last two rejection number are not put there. I have already put it the numbers. Last rejection numbers. It's a third time, Lordship.
Foreigners Act.
Yes, Lordship.
But DKB may not appear regular because the report is necessary. Very much report is necessary regarding the Foreigners Act, Lordship.
Lordship, report in last appearance that the rejected by the Lordship not in merit, in technical ground. So Lordship,
Your prayer was rejected by the
technical ground, Lordship.
what technical ground?
Regular.
Please silence.
The first applications in spite of second application.
Your document was found forced.
No, Lordship, that I have that second applications. There I just mentioned that first application in first paragraph in spite of second applications. That is, but I also mentioned in paragraph 15
your
the same.
voter card, Aadhaar card, passport,
That Lordship,
claiming to
the
be
report
citizen of
as
India
per
are fake.
Lordship, as per my understanding, my report, the report has come and the voter card, ID card is genuine. Also, Lordship, I also that mentioned in my application, Lordship. If you see, Lordship, I put that original voter card is in there, Lordship. Page number, Lordship, 37. If you see, Lordship, that I annexed the voter list, current voter list, and the page number 38, that name and that.
You are appearing for state. No, already there was a rejection order.
Defective has already been.
Defective cured by him. No, earlier it was rejected as the voter card and other documents found fake, as per report of the state.
But Lordship, new report is not come.
Where is the document?
That is, Lordship, I also annexed there, Lordship. Page number, Lordship, 37, 38, Lordship, 852, the serial number of part number 1 and 2 of Rajarhat New Town, Lordship. And second, Lordship, I collect that online his voter ID.
Where you have challenged that report in your application?
Lordship, I
Have you challenged that report?
Lordship, I challenge the last rejection of Bonga SCGM, Bonga ADJ court. That I challenged.
No, your application has been rejected by this court.
The first application rejected, Lordship. That time, Lordship, report has not come. Then, Lordship.
Report came. You go through the order.
Lordship, that time not report came, Lordship. You see, showing that, Lordship, that is the report are not came that time.
So once it is rejected on the ground of fake
that time report has not come from the original authority, Lordship. Second, I applied, Lordship. That time my application is rejected for that technical ground. Third time I came. Definitely, Lordship. And Lordship, the second thing is, Lordship, I came in.
Where is your bona fide? Show us.
That's all, Lordship. Total. I also annexed on in my applications.
That is fake.
No, Lordship. That is original, Lordship. If you show, I am showing that in online now, Lordship. And he came in India, Lordship, as per police.
No, your name is Ashish Rajbansi, alias Ashish Rajbansi.
Lordship, the main thing is, Lordship.
Here you are showing Bakul Rani Rajbansi.
No, that is the not second one, Lordship. On niche, Lordship. I'm showing that. I'm showing that, Lordship.
Where is that?
I'm showing that, Lordship. That's a minute. Just a minute, Lordship.
CD, my lord, how can it be taken up, my lord?
টেনশন হচ্ছে কি তোর টেনশন কিসের জন্য তোর নামে কি কমপ্লেন জানি
And Lordship, if you see the ID number, voter ID count number, same number is mentioned into the charge sheet, serial list, Lordship. And it I collect from Lordship, online, Lordship.
So you verify again.
Lordship already verified last day, Lordship.
Wait.
Oh, sorry.
keep it on the next day lordship everything will be produced by learned friend lordship you
Do you verify this voter card and other document?
Lordship, where is the report, Lordship?
After vacation?
No, Lordship, no, Lordship. It's
After vacation, they will produce entire document.
If you allow me, alternative pairs. It is very much thank you for you, Lordship. I have an alternative pair, Lordship.
It is submitted by the learned council.
Lordship,
About the petitioner, my lord. I'm for the petition.
I will not allow.
My lord, I'm for the petition.
I will not allow any adjournment.
State is not.
CD?
state is not available
No CD.
another
CD is available.
I will
Not today.
I'm for the petitioner.
Not today.
only not
On the prayer of learned council appearing on behalf of the
Minor.
Yes.
My lord, 62 service needs to be affected on the victim because the name has been redacted in the FIR itself. So I cannot affect service.
Service not affected.
I cannot serve, my lord. It has been redacted. The name has been redacted, so I cannot
By the
have
victim.
the address. So let them serve and keep it on the next day.
By the learned counsel. $63.
Will I appear on behalf of the state?
My lord, the de facto 63, my lord, de facto has to be.
You are appearing for 63. What do you want?
My lord, the de facto service has been complete, but de facto.
Kindly direct the state to effect service on the victim.
Despite service.
Victim has not been recovered,
non-appears
victim's family.
on behalf of
Kindly
the
say
victim.
victim's family.
Victim or victim family?
Victim not yet been recovered. This is our fifth application. Last four times your lordship is directing to serve the victim. Kindly say victim's family.
Okay, victim's family.
My lord, 64, I am praying for not.
No, regular bench, my lord, because the co-accused.
My lord, the co-accused person, that was defective, not on regular course it was more because it was defective. That
Same
is.
matter, my lord, it has been posted by your lordship in the regular bench. So I pray, my lord, let both the matter be taken up, my lord. It will be in the regular bench, my lord, both the matters with the same, arising out of the same PS.
So both the application be heard together. Where is the problem?
My lord, that will go to the filing section. There from the record will come. My
No,
lord,
let it.
After vacation, let the matter.
this is not effective, my lord.
My lord, let it.
Where is the state?
I am the state, my lord.
There is no CD. So not today.
Well, at 65 already your lordship fixed, not today, item number 55, arising out same.
Okay, not today. Now, the urgent matters which was mentioned before this court, call that.
66, my lord, kindly 66, my lord. My lord, it is unfortunate case, my lord, kindly see. My lord, it is 21 years boy, my lord. No allegation. 1 year in custody. No allegation. I am showing, my lord, the 66.
There is no time. Other matters I have to take.
66, my lord, kindly take up
If
this.
time permit, I will take. $83.
My lord, when I will come, my lord? When I will come?
এইখানে সরা না
Three, four matters are there.
আমি বলবো কি করে
Well, at 83, my lord, I am for the de facto complainant, my lord, the victim's family.
But 83 I appear on behalf of the state.
Let may I file my the wakalatnama may be filed.
302. 302.
302 seventh application. Murder of witness.
May I please lordship? I am in custody for our last 13 years. My prayer for bail was last rejected on 6th of December 2017 at page 17.
Department
This is FIR dated 5th of January 2013. I am a political person, and for that reason, my lord, I have been implicated in 24 cases. 24 cases out of which I have been acquitted in 16 cases. 9 cases are pending. The trials are pending, and all the cases, all the 9 cases, I am on bail. All the 8 cases, I am on bail. This is the last case which is pending against me for the last 13 years due to political reason. What is the allegation against me? The allegation against me is that after coming out from the jail, the accused persons murdered the witness. One of the witnesses.
Murder the witness.
Murdered one. Just a minute, my lord. It is my application. Now, my lord, for the reason only, standing on the same footing, the coordinate bench of this honorable court. Let me finish.
Absolutely not standing on the same.
100%, my lord. I will have a just a kindly just a second. I am reading that person. That standing on the same footing.
Well, this order we have challenged before the Supreme Court. This is the SLP number. My lord, we have challenged that order.
Let me finish, my lord.
This bail application has been allowed in this case or different?
In this case.
In this case.
In this case.
The accused is on a different footing.
Accused is different. Accused is different.
Different. No, can you look at the page 2 of the order? Page 2 of this order, my lord. Of the order dated 11th of September 2025. Can you look at this order, my lord?
That is under challenge before the honorable Supreme Court.
I am reading, my lord. Landed Council for a de facto competent takes this court to an order passed by this court. Or in this court observed that since the court was deliberately misled the petitioner would not be entitled to renew his prayer for bail till conclusive trial. Landed Council further submits that the offence if proved shall attack mandatory life imprisonment. Landed Council further submits that after one of the co-accused was released on bail by this court, he murdered one of the witnesses of this case. The man who has been granted bail by this honorable court. Now next, after the said order was passed, more than 6 years have passed and trial is yet to be concluded. However, since witness action has been concluded, scope for intimating influencing witnesses can be ruled out. Without going into the merits of this case, solely on the touchstone of Article 21 of the Constitution of India, this court is inclined to release the petition on bail, subject to stringent conditions. My lord, since then, my lord, my condition, my lord, the situation is more better. The court is lying vacant. On the last day occasion, that was, my lord, the last day, my lord, have a look at the order. Just a minute, my lord. I am not finished.
Very shocking.
I am not finished, my lord.
Let him
I am not finished, my lord.
Let him
now, my lord, everything is over. After this bail order, my lord, the de facto complaint has paid for tax.
But the stage of the trial is at the argument stage.
The court is court is lying vacant.
No, High Court has directed. High Court has directed the charge court to take it up.
Taking consideration the bail has been granted. Taking consideration that the bail has been granted, the court is vacant, and whether the next date is
the High Court has transferred it.
November 24. In the meantime, the de facto complaint has paid for transfer of this case from one court to another court in the same session division as Raiganj. Have a look at this order, my lord. The order dated, my lord, order 8th of September.
Kindly see the last para of the High Court's order, my lord.
Order dated 8th of July 2025. Order date. I order the 8th of July 2025. Year of the retracted complaint.
My question is, when one accused has been
Completely
granted
different
bail
footing.
by this court, why parity cannot be
Two
allowed?
things, my lord. Firstly, my lord, so far as the order granting bail,
Will kindly peruse these lines.
On merit, that bail
my lord,
was not
two
allowed.
things, my lord, two things.
That,
My lord, two things.
that bail was allowed on
My lord, may
the
I-
touchstone of Article
Yes.
21 of the
This man,
Constitution.
Yes. 13 years
my lord, kindly consider
No,
this.
13 years I am in custody.
My lord, may I make?
I am in custody
may I-
for 13 years.
এটা পড়ান, my lord. It was not there against that man. It was not there against that man.
It was there. It was there.
My lord, may I make my submissions? My lord, my learned friend will not interrupt me, my lord, when I am making my submissions.
No.
No.
You are interrupting, not me.
And my lord, this person, the petitioner before your lordship, my lord, the petitioner before your lordship stands on a different footing because he was, sir, please. The petitioner before your lordship, he was an accused in the first 302 case. There he got bail. After getting bail, he killed witness of that case.
Another case was initiated
Ismail,
against them.
Ismail.
Another case.
Another
case.
No, my lord. My lord, kindly consider this.
So one by one.
My lord, may I now, he has finished, may I now indicate to your lordship.
Uh,
Biplab Chetri.
Do you submit anything further?
Let them submit.
Yes. My lord, kindly hears me, my lord. Biplab Chetri is now before your lordship. This Biplab Chetri, my lord, initially, he was arrested in connection with a murder case, which is Rayaganj 379. In Rayaganj 379, he gets bail. After he gets bail, my lord, he murders one of the witnesses of that case.
That's why this case is started.
That's why this case is started. So, my lord, so far as the person Ismail who got bail, Ismail was not an accused in that case. Ismail has become accused in this case. That is the first distinction that Ismail has with Biplab Chetri.
So Ismail was not in
the first
accused
case.
of first case.
Right, my lord. So that is distinction number one. Distinction number two is, my learned friend is saying trial court is vacant. My lord, so far as the High Court's order of granting bail to Ismail is concerned, that is now, my lord, sub judice before the Honorable Supreme Court. That has been challenged. So, my lord, that order to today, tomorrow may also be set aside. So, my lord, and thirdly, my lord, so far as Article 21 is concerned, my lord, I have brought a compilation of judgments for your lordships. My lord, Article 20. Firstly, my lord, on 2 points I have brought judgments. One is
that stage is already been over because
my lord, the Supreme Court is now saying, but
argument stage.
Argument stage.
And stage is
and in
argument.
fact, my lord, even if the High Court's order is not set aside, if your lordship sees the High Court order, the High Court has already said, however, the learned court who is in charge of the learned trial court is directed to dispose of the matter expeditiously.
This order was passed in the month of September
last month.
11. So after that, what will happen?
Yes,
that report,
that
report, my lord, will kindly call for from the state.
And my lord, the person who was granted bail.
You file the report. You file the report.
That will be better.
I think that will be the better.
What report, my lord?
What is the stage of the proceeding after direction passed by the coordinate bench?
Very well, one next day.
Next day we are not. Willard, every day this matter is being heard.
November is the next date.
On 24th, I am asking to submit report. 24th.
24th.
I'll take back that.
Because stage is required to be no. Otherwise, what is the stage? No one can say.
On September, with the leave of
let them file that report.
September, next date after the bail was granted to the co-accused, my lord, in the month of September, my lord. Next date was on 6th of September. On that day, my lord, case was adjourned.
So that report let call for.
That report may be.
Do you have that order?
That is the order sheet. That is the order sheet.
Okay.
Where is that?
Have a look at the last order.
Where is that? Which page?
Article 21 benefit is not of universal application. The nature and gravity of the offense has to be seen, my lord. That is what the Supreme Court is now saying. And that is why we have challenged the order.
Milord, we will bring a
That,
report on
that
the
only on the touchstone of article. It's a very serious offense, Milord. He's a repeat offender.
Okay, let the report.
It's a
be
double
called
murder
for.
case now.
Let the report be called for.
It's a very
On
serious offense.
24th.
24th, yes.
20. 24.
Ah, 24th. We flag mark
It is submitted by the learned counsel appearing on behalf of the petitioner.
No, Milord. It's
As
subject
the business of the court permit.
convenience of the regular.
You mention. Report will submit on that day. You mention. Where
There
is the
cannot be an upgradation like this. Oblige me.
I have directed to submit the report on that day.
Twice upgradation he
I
has
have
got.
got a puja bonus, my lord, by calling with an order of my lord.
No, there is no bonus, Milord. We are always at
Okay,
the
next.
Milord, service of your lordship.
101.
Lordship will continue. Lordship will continue.
3-4 matters I have already granted leave.
Without notice, how?
Without notice, I will not hear. I will not hear the matter.
Oblige.
If there is no CD, no intimation, how court can take up the matter? I just allowed, there was a urgency to hear the matter. If you are not ready, how I can hear? Yes. 101. CD is there? No CD.
We are not notified.
Before do you know the practice of this High Court? Before mentioning, you have to intimate other side. This is the procedure of this court. Immediately once morning you mention without intimating other side, how they will know? How will they know? The matter will be taken up today on the urgent basis. Not today.
140, my lord, I am for the petition.
Have you intimated?
I am for the state.
My lord, upon notice, this is my notice. But this is my notice, my lord. My lord, the petitioner.
114, na?
140, my lord.
140.
Case under section 498A 304B.
1 minute. Let me see which item you are placing. 140.
140.
notice. My lord,
Yes, CD.
Well, there's no CD, ma. This is the report what the IO has sent. The CD is lying in the trial court.
my lord, one minute, my lord. My lord, 1 minute, my lord, my lord. Petitioner before your lordship is 95 years old. 95 years old. Case under section 498A 304B. Petitioner before your lordship is the uncle-in-law in village Katsi. My lord, what has happened? He was on bail.
No, I consider your submission that he is
he was on
95
bail.
years, but without CD.
My lord, with due respect, my lord.
Without CD,
I
can
am
this
praying for
application
interim-
be considered?
I am praying for interim bail. With my lord, he was on bail. Kindly have a look into the order sheet. And kindly have a look into the order sheet. He was on bail. My lord, what has happened? My lord, kindly have a last page, my lord. Last page of your lordship's order, my lord, of your lordship's brief. Last page. That my lord.
No, when you have filed this application?
File the application first day of the vacation bench.
First
day of the vacation bench. And Justice Chowdhury and my lord indicated that matter was listed within 1 to 15 matter, my lord. Verbally, Justice Chowdhury, my lord.
Letter will appear top of the list.
My lord, lordship.
And CD be produced on 16.
Produce the communication.
I have said.
I want CD. I want CD on 16.
No, I am in the hospital, my lord. Lordship, kindly pass any order.
In spite of intimation, no CD has been produced from the side of
My lord, for the petitioners, my first respectful submission, my lord, all these accused petitioners, their children.
Have you intimated the other side?
Yes.
When you have intimated?
This matter is being.
Why you have not intimated today?
Matter was listed on 9th.
Maybe, but you have mentioned today for upgradation.
Yes, I mentioned.
So why you have not intimated?
CD is there, my lord.
CD is there, but where have you? Milord, this matter.
CD is present.
The matter, my lord.
CD is present.
No. There are two matters. No, these matters are being upgraded by your lordship.
Yes.
He has to notify the state. Otherwise, how will know? And that too at 15 to 5.
I had the impression.
Not today.
No, my lord, kindly listen to me.
Not today, on 16th.
My lord, kindly, on 16.
On 16. Not today.
16, my lord. I have another matter, my lord, another similar matter. CD has not come, reportedly has not come.
Which item number?
148.
That will be 16.
16.
You have to inform other side at least before mentioning
I had the
upgradation.
I had the impression my junior has intimated. But now I see that it has not been intimated.
195, my lord, I appear for the petitioner. 86-year-old man, my lord, he is in custody. Now, my lord, my lord, on 9th, I mentioned this matter upon notice to the state. Now, my lord, on that day, the matter could not be taken up. Like item number 140, his lordship had directed verbally that this matter would appear within the top 10 matters on, my lord, 14 today. But 86-year-old man who is in the presently admitted in the jail hospital, well, he is in custody.
Whether CD is available?
No, we have given notice.
No, whether CD is available or not.
Well, let it be within the top 10 matters because this person will die in jail. I have annexed all his medical prescriptions. All his medical prescriptions have been annexed.
My lord, I'm praying for not today. CD is not there.
Why you have mentioned?
CD is not there.
Okay, not today.
Only one mentioning, my lord.
One is defective.
I am for the petitioner.
Defective.
Defect is already removed, my lord. But in the first phase,
What
of
was the defect?
first title, my lord. First stage of the first title, there is no mentioning of the case number.
How you have removed the defect without any order?
My lord,
How you have
before
removed
filing, they have informed to rectify your error.
before listing?
Before filing.
এই item number কত আছে?
270.
Item number
Before filing.
70.
At the time of filing, they informed me to.
After listing this matter, how you have entered your
Filing, my lord, before filing, the department rang to me and.
how it appears as a defect?
My lord, I'm quite unaware, my lord. After removing the defect, they still written as a defective.
It is unfortunate to see this.
My lord, may I permitted to mention, my lord? Lord, may I permitted to mention, my lord, item 154. My lord, this matter is time and again being released by every honorable judge, since the de facto complaint is the sitting judge of this honorable court. If your lordship kindly see the complaint. Now, if your lordship want to release, then my lord kindly release it so that I can be listed this matter at any other honorable bench. Now, kindly see the de facto complaint.
No, the matter was released by the coordinate
Yes,
bench.
earlier it was released.
So automatically it will go to the another
No,
bench.
it was released and again listed before your lordship. Now, if your lordship want to take, your lordship can take. But again, if it is released, my lord, my client is in custody only for 424 and
I'm not
406.
taking now.
But
I'm not taking now.
on the top on the next day, my lord, because this
Next
is
day the
released
court
and he
will
is complete
decide.
custody.
The court will decide whether he will taken up or not.
So,
how I can say today?
But only because of the de facto complaints status, this is being released by
If
everyone.
suppose a matter released by any other bench,
My-
automatically it go to the another bench.
Again, I have to wait for release only.
So what can court will do?
But if it is listed on the top of the matter, then it will be
What
decided on the
court
same
will
day.
do? If
Then I will
there
try.
are 4 benches release the matter, court can prevent.
But I will be able to
You
try
can
my luck on
prevent.
the same day, my lord. Because if it is released on the later part of the day, then I will
I
not
am
be
not
able to get
taking up
listed.
this matter today. So there is no question of release or
Saying just
anything else.
to be listed on the 16th on the top within 10 so that I can try my luck on that day.
No, no, how I can direct on 16,
He's
10?
suffering custody, my lord.
No, no.
The entire puja he remained in custody, my lord.
You mentioned before the bench, after notice to the other side. Where is the problem?
Well, anticipatory
If
bail was
the
pending
court
at this honorable court. The
court think fit, this is the urgent case. Court will take
that
up
is
the
a matter.
matter on that day.
If your lordship permitted to be listed within 10 matter on 16th, my lord.
No, no, I have not passed any order. I will not pass any order.
But he's suffering custody. Kindly see the my lord.
I will not pass any order.
His complaint, my lord. The entire family is suffering. His cancer. His mother is suffering from cancer, and he is the only person who is dealing with the. Just kindly see.
CD is available.
One page FIR. Yes,
I will
Debjani.
here and now.
Madam, Miss Debjani Sahu is there. My lord, I have talked to her.
CD is available.
No. Normally, the practice is
One
we
page
go
FIR. Can you see?
chronological.
No, court can take any matter
any
if
point of time.
urgency is there.
But provided we are notified.
That's why I am asking CD is available or not.
Miss Debjani Sahu is there. I have
If the
informed.
CD is not available, I will not take up the matter.
The council is not there. I am there. I am not there in this matter.
Well,
Had
let
I
it
been
be
in this
informed,
matter, I would have
will inform.
definitely adjusted.
I will inform. My lord, kindly visualize the situation. While anticipatory bail was pending, he was taken into custody. One page FIR, your lordship will be amazed to see these type of matters we come for quashing.
You mentioned
Two
before that,
PCs suffered, my lord.
bench when the matter
But
will be
only
taken.
prayer is that it is to be listed within 10 matter.
No, I cannot direct this type of order. So what court will do on that day? You mentioned before the bench. Bench will definitely consider your urgency.
2 years imprisonment without any trial.
No, without mentioning before the bench, I cannot hear. Already in the list.
এটা ওই